So yes, today we are going to complete two other subsidiary rules. These are very important rules. So we started with one. Uh, the first was statutes must be read as a whole, and we discussed how this rule is also related with the other rules that we have discussed. That when we read the statute as a whole, we are able to find out the true intention of the legislature, and the true intention of the legislature can be gathered from the entirety of the statute. But judges are not, that's not what judges usually do. Obviously, the idea is that the statute must be understood as a whole, but not in every situation will the judge look at the purpose, the long title, the preamble to find out the meaning of a particular word at a particular place. It's not necessary. So yes, within a particular provision, a particular word might have particular meaning. So it need not be understood as a particular word need not be understood as having one meaning throughout the statute, unless that's what the statute says. So yes, the idea is that from when a judge is to find out the meaning of a particular provision, it's to be found out using the rule of grammar, using the common meaning as we discussed. But when there is problem, then you remember all other purposive construction that we discussed. Okay. While doing that, judges must read the statute as a whole. That's the idea. So the intention of the legislature is to be gathered from the whole of the statute. And that is known as interpretation ex vis caribus actus, that is within the four corners. So I also told you that the judges first are to find out the true intention of the legislature from within the four corners of the statute. So using internal aids only. Only when that's not enough will it then be justifiable for them to look at external aids. We will discuss those in greater detail later. And the interpretation is to be done so as to avoid contradiction. So remember the rules of harmonious construction that we discussed. And it is to be done so as not to render a particular provision OTOs. Every provision of a statute must be given effect to. That's generally the idea. We will look at those rules. That is also another rule that we are going to discuss later on. And only when the contradiction is completely reconcilable, only in those situations we discussed while discussing harmonious construction, that usually it's said that the later provision, because it comes later, so reflects the latest intention of the legislature, should supersede the previous one. Whereas the other rule that we discussed is that, which is more aptly applied, is that you have to look at the hierarchy of the provisions. Just because something has come up later within the statute does not mean that that reflects the true intention of the legislature, so as to supersede another provision, which is also supposed to be the true intention of the legislature. So if such a situation arises, you are to look at the hierarchy of the statute, and accordingly one supersedes the other. But otherwise, that's not what the judges are to do. Judges are to study look at the statute as a whole, and then give meaning to the provisions of the words of the particular provision. So we discussed the other day that words are not to be taken in vacuo. So prima facie meaning not to be attributed to words. So words are to be, here's something that I need to clarify, that I failed to clarify in the other class. When it is said that words are not to be taken in vacuo, you are to look at the word within the context of a particular provision. It's not saying that the word is supposed to have the same meaning throughout the statute. Okay, so when that is said, okay, the meaning of the words to be drawn from the particular context. Okay, not what we usually understand. Okay, you have to understand the meaning of the word. So remember, within the rule relating to literal interpretation, we found that within a particular trade, a particular word might have acquired a particular meaning. So you have to understand the meaning of the word in that particular context. Okay, just like that, here's also saying that words not to be taken in vacuo, prima facie meaning not to be attributed to words. So it is to read the statute as a whole and ask oneself the question: in this state, in the context relating to the subject matter, what is the true meaning of the word. So yes, subject matter, the context matters a lot. Otherwise the words could have very scientific meaning, which is probably not how it has been used or intended by the legislature. So you have to understand the meaning of the statute in the context. So we discussed further that Lord Davey says that every clause of a statute should be construed with reference to the context and other clauses of the acts, so as far as possible to make consistent enactment of the whole statute or series of statutes relating to the subject matter. So yeah, consistent interpretation, okay, to avoid contradiction. That's what we discussed in harmonious construction as well. So the statutes are to be read in totality. Similarly, Lord Coke had said, it is the most natural and genuine exposition of a statute to construe one part of the statute by another part of the same statute, for that expresseth the meaning of the makers. But that's fine, not in every situation will you restrict or enlarge the meaning of a word in a particular part of the statute by reference to another part of the same statute. Okay, so those words could have different meaning or could have been intended as having different meaning in different parts. But generally, this is the position what Lord Coke is talking about. So yeah, we discussed many such rules the other day. So let's look at some cases to see what this rule actually means. Let's start with this particular case. So yeah, we are concerned with this particular case by the name Commissioner of Wealth Tax versus Officer in Charge, Court of Wards, 1976. Okay, so we are concerned with the meaning of the word, words agricultural lands, agricultural lands, so whether something constitutes as agricultural lands, hence excluded from the definition of assets, so there's a definition of assets given under section 2E of the Wealth Tax Act 1957, and agricultural lands, are an exception to the definition of assets, The question was whether the land here in concern, falls within the meaning of agricultural lands. If it does, then it will be exempt from tax under the said act. So you see, I think the High Court, the High Court had taken a very broad approach with respect to the matter, and defined the word agricultural land in a very broad way. So if you look at the case, you will find in the head note, you will find the High Court held that the land was agricultural land under section 2EI of the Wealth Tax Act 1957, and hence exempt from wealth tax on the basis that the expression agricultural land, the expression that we are concerned with, has not been defined within the act. So must be given widest possible meaning. So interpreted, all land which is capable of being utilized agricultural purposes would be agricultural land unless it is actually put to some non-agricultural use like construction of buildings. So their definition is like this, unless it is used for non-agricultural use, it will be considered as agricultural land. So that's a very wide approach taken by the High Court, So it further finds that the land has been assessed to land revenue as agricultural land under the state revenue law. So the matter comes before the Supreme Court, as an appeal. So it reverses the definition, the judgment first, and then also it defines the word agricultural land in a much restricted way, So you see the word agricultural land is now being defined within the four corners of the act, ex vis caribus actus. It's not being given a very wide meaning, but a restricted, a constrained meaning as the purpose of the act, allows, So it restricts the meaning of the word agricultural land. So now the other approach which has been taken here is that unless the land is being used for agricultural purpose, it is to be considered as not, agricultural land. So if it is being used for agricultural purpose, then it will be used as agricultural land. Okay, so it said the object of Wealth Tax Act. Okay, so it's looking not just at the words, okay, but also the object. The object of the Wealth Tax Act is to tax surplus wealth. It is not all land but only agricultural land that is excluded from the definition of assets. Therefore, it is imperative to give reasonable limits to the scope of the agricultural land. Because if we increase the ambit of this expression, then many land will be exempt from the purview of this particular act. So the court gives a much restricted interpretation to the words agricultural land. Now this it does, okay, within the four corners of the act, looking at the purpose, looking at the totality of the statute, not just the specific words, because if those words and expressions were only to be looked at, then the High Court would have come to the right conclusion. As opposed to High Court, the Supreme Court held that, well, it is to be understood in a much narrower sense of the words. So that's what it says. So in the judgment, it said that the correct rule is that we have to endeavor to find out the exact sense in which the words have been used in particular context. We are entitled to look at the statute as a whole and give an interpretation in consonance with the purposes of the statute and what logically flows from the terms used. We are to avoid absurd results. Okay, so you see how this particular rule has been applied in this particular case. The next important case is by the name Corporation of City of Victoria versus Bishop of Vancouver Island, also known by shorter name Victoria versus Bishop. Sorry, the previous one didn't reach you guys. So look at the second case, okay? That's the one I'm concerned about right now. So yes, I will share a link, okay? I do not have the original judgment, but there's an Indian case where it has been referred and the same approach has also been taken, okay? So you will find it here. This rule has been applied here as well. So you see, we are concerned with section 197 of Municipal Act, okay? Clause 52, Statutes of British Columbia 1914. So this particular provision provides tax exemption, okay? This particular provision provides tax exemption to every building set apart and in use for public worship of God, okay? So we are concerned about whether this word building here, every building that is being talked about here, so will the word building consist only of the structure, okay, or also the land on which the building has been constructed? So you will see here, if you go to this particular link that I have given, okay, here it is discussed, okay, in one of the paras. I think para 12 you will see it's discussing the same case, okay, which is also the conclusion that in this that the court had come in this case as well. So you see that it is difficult, however, go to para 12, you will find it there. It is difficult, however, to determine the interpretation of the word with reference to dictionary meaning, where we have the highest authority, okay. And the Privy Council in Corporation of City of Victoria versus Island, this particular case, in which at 3 separate places, Lord Atkinson, speaking for the Judicial Committee of the Privy Council, has clearly indicated the popular and ordinary meaning of the word, okay. The question will be whether there is anything in the statutory provision from which it can be clearly suggested that the ordinary and popular meaning of the word building is to be abandoned in preference to the more restricted meaning as referred to the superstructure, which meaning is canvassed by the learned advocate on behalf of the SSC. So anyway, you see that you can go on and look at this case as much as possible. So all that is saying is that you have to understand the meaning of the word in the context of the statute. Okay. So in the context of that statute, it had come to the conclusion that building includes not just the structure but also the the land on which it has been constructed. So in the construction of statutes, their words must be interpreted in their ordinary grammatical sense unless there be something in the context or in the object of the statute in which they occur or in the circumstances with reference to which they are used to show that they were used in special sense different from their ordinary grammatical meaning. So building in ordinary grammatical meaning would mean merely the structure, but here in the context of this particular act, it would be absurd to hold that only the structure constitutes building and not the land on which it is built. So that's the conclusion that it had arrived at, okay, departing from the the ordinary grammatical construction, and took a very purposive construction. So, and that was done by looking at the four corners of the statute, and hence this was also an application of the rule of statutes must be read as a whole, or ex piscatibus actus. So, are you guys with me till now? Am I making sense?
Yes, sir.
Okay?
Yes, sir.
Yes, sir.
Yes, sir.
Okay then.
Yes, sir.
Okay. We'll take one more case, okay, that goes by the name Kedarnath versus State of West Bengal. Oh, sorry. Yeah, Kedarnath versus State of West Bengal, 1953. Okay. So, in this particular case also, okay, what had happened was Section 4 of West Bengal Criminal Law Amendment Act 1949 was challenged, okay. It was claimed that it offended Article 14 of the Constitution of India, okay. So, how did it, violate? So, it made reference to special court for trial, okay, by special procedure that denied advantages of ordinary procedure, okay. So that was appealed. Sorry, that was to be considered as, that was challenged as violating Article 14. However, the Supreme Court rejected this contention, saying that the act is entitled. Okay, so look at this. Okay, it had looked at, in this particular case, the court had looked at. Now I'm not going into the the quality of the judgment, okay, I'm just merely referring to how the rule has been applied. So I'm not saying that you cannot disagree with the judgment, but you see how the court had interpreted the particular, particular provision of the act, okay. So it took help from one of the internal aids, okay. And what is that? The long title, okay. So Supreme Court rejected this particular contention based on its reference to the long title. And what does the long title say? So it said the act is entitled an act to provide for the more speedy trial and more effective punishment of certain offenses. And the real issue is whether, having regard to the underlying purpose and policy of the act, so you see that's the title, okay, an act to provide for the more speedy trial and more effective punishment of certain offenses, okay. This is the act, okay. So why was it created, okay? And the real issue is whether, having regard to the underlying purpose and policy of the act disclosed by its title, so as the title says, etc., the classification of offenses for the trial which the special procedure is set up can be said to be unreasonable and arbitrary. And the Supreme Court came to the conclusion that it is not unreasonable, arbitrary, because there is a reasonable classification. So, and accordingly, so you see, by looking at the title of the act, it came to the conclusion and rejected the claims made by the party here. So that's so you see that not just the provision, okay, which was looked at, but also other provisions in order to understand the context in which the particular provision was used. So you can say that this is an application of the, as long as they are not just referring to the particular provision and looking at its constitutionality, but also looking at other provisions. But I think you will get better examples than just this, okay? But this is just one of the examples where it has been applied. I will take one more case, okay, and that's by the name State of West Bengal. There are many other cases, so you will find enough. Okay, so this is the next important case. So this goes by the name State of West Bengal versus Washi Ahmed. Okay, so let me also share this link with you guys. go to the head note here, okay, and you will see this particular case. Okay, so in this particular case, we are concerned about this particular act. Okay, section 6(1) of the Bengal Finance Sales Tax Act 1941. Okay, that exempts from tax liability certain vegetables. Okay, whether green or dried, that is commonly known as sabji, tarkari, or sak. So when it is not sold in containers. So if this is the condition, okay, so these requirements are fulfilled. So it has to be vegetable, whether green or dried, okay, also known as sabji, tarkari, sak, okay, when not sold in sealed containers. Now the question is whether ginger, okay, will also come within the meaning of this particular term called vegetables. So it was held that ginger is included within the meaning of the word vegetables. Now you know that if you go by the technical meaning, okay, scientific way of defining vegetables, you will think ginger is a kind of tuber, isn't it? So it will not scientifically come within the meaning of the word vegetable. Okay. Now that's not how we understand the word vegetables, though. Okay, commonly the word sabji, tarkari, or sak, okay, I mean vegetables as we understand, okay, are used in a much broader sense, so as to include even ginger. So it was held that ginger is included, okay, within the meaning of the words vegetable in item 6 of schedule 1, and its sales are exempt from the tax under section 6 of Bengal Finance Sales Tax Act 1941. So the word vegetable, though not defined in the act, okay, so how the rule has been applied. See, the word vegetable, though not defined in the act, being a word of everyday use, must be construed not in any technical sense, nor from any botanical point of view, but as understood in common parlance. That is, denoting class of vegetables which are grown in kitchen garden. See, this is something that we saw in another case before. In a farm, and are used for the table. Okay, the word vegetable in item 6 of schedule 1 to the act so construed by giving its popular sense meaning, that sense which people conversant with the subject matter with which the statute is dealing would attribute to it, denotes those classes of vegetables which are grown in the kitchen garden. Okay, so whatever, we understand what is being talked about. So there's a particular purpose for which the act has been created, okay, although the act in itself does not define the word vegetables, but from that we can conclude that, well, clearly this is not supposed to come within the ambit of the application of the said provision of the act. So that's just another application of the rule, statutes must be read as a whole. So that means you do not just look at the specific provision, but also the purpose, the context, the long title, short title, whatever internal aid you can take help from in order to find out the true intent of the legislature. And that's the application of the rule called statutes must be read as a whole, or ex vis caribus actus. So that's one more rule. We'll take one more rule today, and that should be enough for today. So the next rule is by the name Utres magis valeat quam pareat. Okay, so here's the next. Okay, so yeah, I failed to mention one more thing. Okay, so in the previous one we saw that, okay, it says that statutes must be read as a whole. Okay, so another rule that goes with it is the idea of casus omissus. Okay, so if something has not been omitted, we discussed this earlier as well, okay, within the literal meaning. So the judges are not to assume that it has been omitted. Okay, so and then that goes with it, and we will study that as another rule later on. So the next one is utres magis valeat quam pareat. Okay, what does this mean? Okay, it means it is better for a thing to have effect than to be made void. Okay, so in a particular statute, every single word which has been put there, every expression is to be given effect to. Okay, we are not to assume that the legislature merely put those words, expressions there without intending them to have any effect. Okay, that's not what the judges are to assume. So judges are to keep this in mind, that everything has to be given effect to. So if there are two interpretations possible, okay, the one that gives effect to a particular provision, okay, is to be adopted, as opposed to one that renders it ineffective, that renders it void. Okay, so it is said it is better for a thing to have effect than to be made void. So statutes are to be construed to make it effective and workable. Okay, so if two interpretations are possible, one that renders it ineffective, okay, unworkable, but there's another that makes it effective and workable, judges are to go with the one that renders it effective and workable. That's the idea. So this rule has been applied in many cases. So in this particular case, just a second. In this case, okay, Tinsukia Electric Supply Company Limited versus State of Assam and others, 1990. So it was a quote, okay. The courts strongly lean against any construction which tends to reduce a statute to a futility. The provision of a statute must be so construed as to make it effective and operative on the principle ut res magis valeat quam pareat. Okay, so that's the rule. Statutes and its provisions and words are to be given effect to, rather than rendering them OTAs or unworkable or ineffective. Okay, so the statute must be construed to give them a sensible meaning. Okay, however, there might come a situation where it just does not make sense. Okay, it's just completely vague. Okay, completely vague. Those situations do not arise though. Okay, but it's not completely unseen. Okay, so if those situations, but those are extraordinary situations, you don't see that every other day. Okay, in only those situations can the court still, with abundant caution, say that, well, it is void because of sheer vagueness. Okay, so it does not happen very often, very rare situation. So in Salmon versus Duncombe, 1886, I'll just write it here. Okay, in this particular case, it was said that it is only in when the provisions are completely intractable. Okay, so when there is absolute intractability of language used, okay, when it is impossible to resolve the ambiguity, okay, only in those situations can the particular provision be said to be void because of sheer vagueness, and not otherwise. Okay, so you don't see this happening every now and then, or very rare occasion. Okay, so in Manchester Ship Canal Corporation versus Manchester Racecourse Company, 1904, okay, in this particular case it was said, unless the words were absolutely senseless, okay, that I could do nothing at all with them. So you see the kind of extent to which the judge has to go. I should be bound to find some meaning and not to declare them void for uncertainty. Okay. Similarly, Lord Dunedin in Murray versus IRC, it said, it is our duty to make what we can of statutes, okay, knowing that they are meant to be operative and not inept, and nothing short of impossibility should, in my judgment, allow a judge to declare a statute unworkable. So it's the application. So it says nothing short of impossibility. So only in those extreme situations. Otherwise, it is to be given effect to. Okay, so we have a case by the name Avtar Singh versus State of Punjab, 1965. Okay, so this is the case in which we are concerned about the application of this particular rule. Okay, so what are we concerned about? So in this particular case, the appellant was convicted under section 39, okay, of the Electricity Act 1910. And section 50 says no prosecutions shall be instituted against any person or any offense for any offense against this act or any rule, licensed or ordered thereunder, except at the instance of the government or a state electricity board. So if you are to convict a person under this particular act, the said matter has to be so this prosecution shall be instituted, okay, against any such person if it is under this act, then with the license or order thereunder, okay, except at the instance of the government or state electricity board or whatever. Okay, so if you are to prosecute the person under this statute, then it has to be initiated by this person it is being talked about. Now, in this particular case, how was electricity to be understood, as theft? Because you will not be able to consider, electricity theft as a case of theft under IPC. Okay, that's not possible. So by virtue of a fiction, the same could be extended. Okay, and then the said person would be punished under the IPC. Okay. But that's not the interpretation that was, accepted in this particular case. Okay, when it came as a matter of appeal. Okay, so the conviction of the appellant was set aside. Okay, it was held. The dishonest abstraction of electricity mentioned in section 39 of the Act cannot be an offence under the IPC. IPC alone. It is not an offense, because under the IPC alone it is not an offense. You have to carry the fiction. The dishonest abstraction is by that section made theft within the meaning of the code. Okay, that is an offense of the variety described in the code as theft. As the offense is created by raising a fiction, the section which raises the fiction, namely 39, must be said to create the offense. Now, if the offense is created by 39, then obviously it's said that you have to fulfill the requirements of section 50 as well. And because the requirement of section 50 was not fulfilled, so that's the reason that the conviction of the appellant was set aside. So you see, it says in this particular case that we will not render section 50 ineffective. Okay, we will not render section 50 ineffective. So it says words of an act of parliament must be construed so as to give sensible meaning to them. Okay, the words ought to be construed ut res magis valeat quam pareat. So they would go with the interpretation that will not render section 50, which requires no prosecution shall be instituted against any person for any offense against this act. Okay, this act or any rule, license or order thereunder, except at the instance of the government of the state or a state electricity board. So this requirement will not be rendered odious. So that's how this is an application of this particular rule, that is ut res magis valeat pareat. Well, so we have one more case. Okay, it is by the name Corporation of Calcutta versus Liberty Cinema. Okay, in this particular case also you see application of this same rule. Okay, so we are concerned with section 548 Calcutta Municipality Act. Okay, the respondent was paying annual license fee of rupees 400 per year. Now later on the basis for assessment was changed by resolution, okay, to rupees 6,000 per year. So the High Court had quashed the resolution on a writ petition. The Supreme Court then reversed the order and held the levy to be a tax and not fee. Okay, so if it's a tax, then it meant that it can be, even though it was changed from 400 year to 6,000 year. Okay, it could be allowed to be changed through resolution. Okay, through a resolution of the municipality. So it goes on to saying, statute has to be read so as to make it valid, and if possible an interpretation leading to the contrary position should be avoided. Okay, it has to be construed ut res magis valeat quam pareat. So it goes with the interpretation that makes the said statute valid, that renders the particular provision of a statute valid and not otherwise. Okay, so that's it. Okay, so that's the next rule. Okay, so tomorrow we are going to discuss about presumption of constitutionality of a statute.